Request to all of you, if you all could put yourselves on mute. Good evening, the lovely. Soma, you'll have to put yourself on mute.
Yes.
Thank you. So good evening, everybody. Thank you for joining. And I know it's a very interesting topic, which has drawn a lot of interest. And I have been continuously getting a lot of phone calls, inquiries. What is it that you're up to? So I think we will get started. I'll pull up my presentation in 1 minute. We're all live on FB and we'll be sharing few very interesting cases. And I have enthusiastic lot of panel members here whom I'll be introducing in a minute. Over to you, Madhura.
Yes, Smita. Hello, everyone. Good evening. A warm welcome to today's session on the POSH law, where we are discussing tricky cases. I'll quickly introduce ILA, Indian Lawyers Association, which started about 2 years ago. We are a not-for-profit organization doing a variety of activities for legal professionals across India. And we have a presence in 70 plus cities so far. And we aim to be in all 100 and more cities, topmost cities of the country by end of this year. So we host events for professional education of lawyers, giving them networking opportunities, provide mentoring and any kind of support to law students or young lawyers. So
I think we lost Madhura. Madhura, we can't hear.
We basically are doing a lot and we still hope we do and vote soon. So can you hear me now?
Yes, yes. Please go.
Okay. So basically I'll send a detailed email to all the participants tomorrow for what we do. And we would also love to see all of them helping us do things for bettering the legal profession. Smita, over to you. Great moderation from you as always. Very enthusiastic and energetic role that you have been playing throughout the series. Over to you.
Thank you, Madhura. That's really kind of you. A little bit about myself and our company. I am the CEO and co-founder at Gelp HR. Have been running this company for the last 8 years. Prevention of sexual harassment has been very, very close to my heart because I've been working in this space prior to the law came in, right from the time Vishaka guidelines was up and there. And we've seen it, the entire process of what happened to it and now. And there are a lot of things which are not really written. So here with me, I have some really enthusiastic panel members who are going to help us understand which is not written, or if it is not written, how do we, how do we understand that better? How do we decipher it better? Okay, so that's about my company, about me. Total of 23 years of experience. Have been an HR person all my life. So you can see the DNA of HR person always. I've been a POSH and DNI SME. So diversity and inclusion is another space, and mental health or employee assistance program is something that we constantly and consciously are working because we understand the world that we are living in. It has changed over the last 1.5 years. Okay, and mental health is something that we should be watching about. So this is about me, and now about the favorite people that I have today here. I start with the only gentleman on the group, Abhinav Rastogi. He's a counsel at Khaitan & Co. Delhi and works with employment, labor and benefits practice of the firm. So Abhinav specializes in employment law and compliance matters. So he has been actively involved in general to complex employment matters. Abhinav regularly contributes in articles, updates on regulatory and policy development and in employment law space. Abhinav has been listed in the Next Generation Lawyer by Legal 500 consecutively from 2016 to 2019. That's quite an achievement for the young lawyer that he is. Congratulations, Abhinav. Really proud of reading what you have achieved, right? And I have lovely Anjusha with me. I've known her for a couple of years and been working together. So she is an HR business partner, strategic HR business partner in a healthcare IT organization. She has a total of 14 years of experience in various diverse HR functions and has been working passionately in the areas of leadership development, OD, conflict management, change management, workforce planning, and performance management, of course. She has ample experience as an IC person, okay, in the prevention of sexual harassment, of course, the internal IC member. And trust me, with every time I meet Anjusha, she has something very different to share. So I thought when the tricky cases was there, I thought it was the right thing to get her here. She's also an inquiry officer in grievance redressal committee of her organization. And her mantra is never stop learning because life never stops teaching. That was so profound. I thought it was important for me to share this with you all. And the last but not the least, the most dynamic here we have Sam, or she's known as Sam, but her name is Samprita. Okay, she's associate at IC Universal Legal, having 3 years of experience. The most profound statement is that she is a rank holder in Karnataka State University, and she got 3rd rank. So that was so profound, Samprita, short, sweet, and there I am. I have arrived time. So thank you very much, all of you. So we'll start with the gentleman. Any quick thing, Abhinav, you want to start about the topic, about yourself? Have I done justice to your introduction?
Thank you so much, Smita, for the wonderful introduction, and all the participants here, fellow panelists. At the outset, what we are discussing today is a very, very sensitive topic. Most of the things are not black and white. They fall into the gray domain, which we would be discussing so that we could provide our insights or our experience or basis the situations what we have dealt in the extent scenarios to help the members who are attending to navigate through these issues. As we all know, POSH is a gender-specific act and based on preponderance of probability, sensitive issue, and which should be kept in mind at all workplace at all times. Thank you.
Awesome, Abhinav. That's really nail on the head. Tuck. Moving to Anjusha. Anjusha, you would want to say anything at the beginning?
So first of all, thank you, Smita and KelpHR team for giving me this opportunity to talk about this sensitive subject. When we say it is sensitive, we all have to understand that there's so much of confidentiality involved in any case as IC when we deal, as HR when we deal. So my urge to the fraternity who are either in the committee or as HR, I think if we lead with courage and integrity, I think that's when we can help people come out of very difficult situations. So that's all from my side.
That's an HR person talking, right from that. Sam, I would want to hear from you quickly.
Yeah, so my approach is that POSH cases should be dealt with, with a lot of sensitivity. One thing. Second is that in an organization, the entire mechanism, right from initiation of complaint till, the action is passed by the IC, all that should be regulated, and, there should be enough support from the employer when, there's a grievance from the complainant, so that people come forward when they face such issues, because it's a sensitive issue, so that people can have a safe work environment.
Absolutely. The larger role is of the employers. And I think here people who have joined in and people who are watching us live on FB, many of them or most of them are employers. They want to know what more, right? So Sam, thank you for that. I have a big announcement before we get started, okay? And what is that big announcement? We are launching POSH Awards, okay? In India, this is a very unique, in fact, in the world, this is very unique. No other company does Prevention of Sexual Harassment Awards. You must have heard about Great Places to Work, you must have heard about various other awards, but this is our big thing. We did one round in 2020. This is 2021. We have taken a little time because we wanted to do it personally in being part of in physical space, but I don't think it is possible. So finally, we decided to do it online. So please keep watching the space. Coming week, there will be more announcement. Please follow us on LinkedIn, Facebook, Twitter, Instagram, you will be getting a lot of input. The reason why I'm putting it here, because I know a lot of organizations have joined in. You should apply for this. At least you will get to know what other organizations are doing and where we can go. And for all you know, you will win it. We always think, oh my God, should I, shouldn't I? Yes, you should, right? So this is what was my one big announcement. Now I directly, without taking a lot of your time, directly get into cases. And here we are. So this is the first case that I would want to share with you. Anybody wants to read? Any of the panel members, would you want to jump in and read? Anjusha, can I come to you?
Sure.
You want me to read? I will read. So this is about a hostile victim, Anjusha. There are two colleagues. Actually, this is something that we went through. Reena and Rajiv are colleagues working on the same project. Reena started to receive calls and messages to talk about project from Rajiv in odd hours. She clearly mentions to him on message not to call her in odd hours. One night she receives a message that I'm feeling lonely. Can I come to your PG for our remaining project work? Reena got scared and spoke to her HR. HR gave her guidance to file a IC complaint. Now, Reena does not want to file an IC complaint out of fear, purely out of fear. So, Anjusha, what do you think as an HR, as an organization, can you do?
Sure. So as HR, we deal with reporting paralysis when women employees do not want to report sexual harassment. In this case study, she has some fears. And I think it is important to understand these fears and address them first. Also, make her comfortable about the process of investigation. Once she's comfortable, she understands, and she is, out of those fears, there are possibilities that she can file a complaint. In my opinion, this is a reactive approach. Let's look at what can be a proactive approach so that we don't get into such situations where women do not want to complain. I'm not talking about malicious complaint, but very specific to such complaints. And we must spread awareness by training our employees, IC, and leaders at regular intervals. Posters and emailers are also good way to spread awareness at appropriate intervals. But again, I feel that there is a deep-rooted problem. These are good. I mean, this is definitely we need to do to spread awareness. But when we look at the problem statement, I feel a woman should be courageous and stand tall for herself with integrity and honesty. We have women-specific forums in many organizations, and we do celebrate Women's Day, and we do a lot of learning activities in these forums. Can we think of interventions and nugget programs for them to be able to develop these competencies? Let's throw them into the ocean of role plays to deal with difficult situations and stand tall for themselves with honesty and integrity. Whether it is to deal with a small problem of speaking in a meeting or a big problem of dealing with sexual harassment, let them deal with it in various difficult simulations that we can think of. Let me tell you, Smita, a woman is like a tea bag. You never know how strong she is until she gets into the hot water.
Awesome, Anjusha. That's quite a profound statement for me. And I really liked your suggestions about dealing with this kind of a situation and how it is important for organizations to be proactive rather than reactive. Yes, a lot of people say, in fact, in my day-to-day conversation, I hear people saying that, the cases are not come, so it's okay, we are good. But I must tell them that they're sitting on a ticking bomb. There's something amiss. Please check. Yeah. Thank you very much for that. Anybody, anything y'all want to add, please feel free to add. Abhinav, Sam, please. Confidentiality. This is another one. The complainant spoke to this. I'm coming to Sam, to you. Okay. The complainant spoke to her HOD about the inquiry on the complaint that was filed with internal committee. So during the complaint was in process, she must have spoken to the HOD. Now, as an IC person, what should you do? Is it a breach of confidentiality already? Or no, it's okay to talk to your manager? Or maybe she was only asking for relief for herself. What do you think should be your thought as an IC member?
So firstly, under the Act, Section 16 provides that, notwithstanding what is contained in RTI Act. So RTI Act basically tells that any person who wants any information in accordance with the provision of that Act, they can, file an application to obtain certain information. So it supersedes the provisions of 16, supersedes such Act to state that any information relating to the identity or the witness or the inquiry, conciliation proceedings or the complainant, should not be disclosed or communicated, published in media, print, or in the public domain, basically. And it says that it can, the only exception is that it can be disclosed to show that justice has been obtained or secured without disclosing the identity of such persons or such details. So the only to safeguard the interest of the aggrieved women and the witnesses. So that's how it states. Now, public is not defined under this Act. So public, we can take reference of from Section 12 of IPC, Indian Penal Code. So there it says that public means any class of public or any class of community. So what we understand from this is that based on like certain judgments also, which I'll get to in a bit, is that whenever the parties are involved in an sexual harassment proceedings, or there's a proceedings that's already begun, and that scenario, the parties themselves, that is the complainant and the respondent and the members of the IC, are strictly bound by non-disclosure. So also, if we look at the provisions of the Act itself, it says that even for the members of the IC, there is a strict requirement that they should not violate the provisions of the Act, and in case they do, they'll be disqualified as members of the IC. Now, during the pendency of the proceedings, the complainant has spoke to her HOD about the inquiry, which is also, if we look at Section 16, it specifically talks about inquiry in its purview. And it says that any such information relating to the inquiry should not be disclosed to any person. Now, one important aspect is that public also includes any third party. Okay, so third party being any party who is not the party who's not the parties to the proceedings and the members of the IC. So it's very limited to that. So also the second aspect that we have to look at is that because the proceedings have not been concluded during the course that they are pending, there is a lot of risk involved and there's a lot of uncertainty as to the evidence first. Second is that as to what is the authenticity of the allegations that are made. So only when IC comes to the conclusion based on the allegations, based on the evidence, that we'll get to know that, or the IC comes to a conclusion, only then it formulates a report under Section 13(1) of the Act, which states that and it gives to the employer, directing the employer to take up certain actions. So in that scenario, disclosing any such information prior to conclusion of the proceedings, in my view, it is not supposed to be done because it will amount to breach of confidentiality under Section 16, and there's also a penalty that's imposed. But other than that, they should not be disclosing such information to any third person, including the HOD in this case, because it also prejudices the interest of the respondent and to certain extent even the complainant, because it's not been proven. So
absolutely, thank you, Sam. And one thing that comes to my mind is the responsibility of HOD. Can HOD push her back, saying that, listen, lady, he's the leader, he's the manager of that person. So I understand that you want to speak to me, but remember that there is a confidentiality pact you must have signed, so do not discuss about it. What do you think about that?
Yeah, I totally agree that the HOD is supposed to be aware of the laws, and that's why we have trainings. That's why the employer should also even though ignorance of law is not an excuse, the HOD or any other employees for that matter, the employer should basically, have these training sessions where they equip people with all these, provisions of the act, the procedural aspects, so that people know. Other than that, the HOD HOD himself or herself does not have an obligation in a way that, tomorrow if the HOD, doesn't state or doesn't advise the complainant that she should not disclose, there's a penalty imposed on the HOD. She will have to tell the complainant that she's not supposed to disclose anything to her as of now, until the conclusion of the proceedings. But until then, yeah, there's no obligation as such. Also, I wanted to add that under Rule 12 of the POSH rules, there it states that if any person violates the provisions of Section 16, then in that case, the employer will be entitled to collect rupees 5,000 from such person who has committed such violation. Yeah.
Another thing, Sam, I would want to bring to your attention is, people speak to their head of departments or managers or leaders, not only because they are, wanting their help in a particular case, but also they feel that they are somebody whom they can reach out to when they are in agony, when they are seeking empathy, when they need courage, all that thing, right? So
Yeah.
that encompassing in today, the life that we are living, so much of stress around, you want to speak to somebody who will understand what you're going through. So it's a very, it's a very
Dicey
thin
situation.
yeah, it's a very thin line. So
Yeah.
in such situation, I recommend, that confidentiality is prime, right? But HOD may not be geared up to handle such conversations also. So I think very gently he or she, the head of the department, should ideally push her or recommend her to get IC to push her to meet a psychologist, somebody who's trained to handle her sensitive situation. I think that is another thing in our trainings, as you rightly said, Sam, that we have to conduct these trainings, and these are some clear, glaring messages we should be passing it on.
Also, I want to add that, so how do you bring about the awareness about POSH Act? So basically under the act, it says that every employee, like wherever it's applicable, the act is applicable, and the act is applicable to 10 or more employees, whichever establishment has 10 or more employees. So in that case, they have to formulate a policy in accordance with the POSH, Act. So in that, if it's like that also, the employer can go a step ahead and then, even include aspects like these, where, they can include clauses relating to whom they should approach, in times of help and all that, without disclosing the, anything about the proceedings, identity of the parties, witnesses, anything like that. So that sort of help can come only if it's regulated, and it will be regulated only if there's a POSH policy formulated. And if the employer also, there's penal consequence to that if you're in violation, if the employer is in violation of not having a POSH policy. So under the act, yeah.
Yeah, that's very interesting, because lately we were discussing, one of my clients circled back to me saying that they have missed something, to do what they were supposed to do. They had to change the number of people. As per law, there is a requirement.
Yeah.
Every 3 years, they have to have new set of IC members.
Correct.
So they missed it. All right. So the question was, is it non-compliance? Will they be penalized for that? So we were grappling with that situation, saying, yeah, they can always go back and say, sorry, we missed it. Didn't mean that because of pandemic, we completely slipped our mind. So this was another thought which was going on. And he said, it's okay to say we missed out, and, we'll now change it, right? Is what came up. If you all have any thoughts on that, please share it.
Just to add on Sam's view here, I mean, sensitizing employees is also a major obligation which is entrusted to an employer. And how do you sensitize? Most of the people I've seen, they say that they take that as just a compliance obligation which they're supposed to fulfill. You should have external speakers, or you should engage with external organizations who are well equipped to deal with such matters. A. B. Training of IC members also become very important in such scenarios. So these just a couple of views to add to Sam's thoughts.
Yeah, thank you, Abhinav. That's very, very important and constantly working. And that's the reason why ILA and KelpHR came together to form
Yeah.
this kind of an association where we are actually giving it back to the society, saying that, we get these eminent speakers whose brains you can pick and ask those questions, but please do this, keep sharpening yourself is the idea of this conversations. All right, Abhinav, we come to you.
Sure.
And now this is a situation. I work from Chennai and my unit head works from Mumbai. My unit head has been talking in double meaning dialogues for a long time in team meetings. And everyone just laughs it off. He says he's only trying to lighten the work stress of everyone. Last week, when I traveled to Mumbai, he cracked another joke and passed a comment pointing at me. We men know everything about your sizes. Why can't women learn about car models? My teammates were present too. It was very, very embarrassing. Can I complain? Which IC should I complain? Because now this is Mumbai, Chennai. So which IC should I complain to?
So sure. So it's just not embarrassing, it's derogatory as well. It's outraging women's modesty as well, but we are not dwelling into those aspects of IPC here. So I'll restrict myself and refrain myself and answer only from posh perspective. The words your size definitely have a connotation of sexual harassment element in it. This would definitely fall within the purview or would squarely fall within the purview of the definition of sexual harassment. It's sexually colored remark and not acceptable at workplace at any time. So definitely she can complain. Now the question which is imperative here is where she should complain. So the idea here is that if a complaint gets through, or if a person is, or if the misconduct is proven, or the IC finds out that a person has, or the person has been charged with the crime has been committed by the person. So what the person very stationed would be responsible for taking any disciplinary action as against the concerned employee. So here, if the person is situated in Mumbai, the IC of Mumbai would take up the matter. They would interrogate, they would investigate, they would inquire, they would close the matter. That said, it's very important that the local committee at Chennai also kind of collaborates with the IC of Mumbai. When I say collaborate, it is in terms of providing all assistance to the complainant at the outset, and may also join the proceedings by virtual mode or virtually whenever the hearing is being taken or when the matter is under reference and is being inquired by the IC at Mumbai. So that would also provide adequate comfort to the complainant. But primarily, it should be reported to Mumbai because the underlying objective, or if it's proven that he committed this kind of crime or this kind of act, he would be punished by the disciplinary committee at Mumbai office.
Yeah, this is always a situation, and not only location, internal location, but also client and vendor relationship. Where should it get posted? So this is always, so what you're saying, Abhinav, is the respondent's IC is responsible, right?
Yes, that's correct. That's correct. That is in Mumbai.
That is in Mumbai. Thank you so much for that. I come to Anjusha again. Anjusha, this is about romantic relationship. Now, this case is Roma and her teammate were dating for almost a year. After they broke up last month, he has been acting out. He follows her around, and last week he cornered her in the break room and touched her. Considering they were dating and it was a personal relationship, can she still complain to IC? And trust me, mutual relationship and IC is a big challenge.
Yeah, it's very tricky. I mean, I would definitely give my opinion, but it will be very good to hear from the other panelists, the lawyers, on this particular case. So, in my opinion, in this case, they had a breakup, and then if there is an inappropriate behavior and the woman is impacted, she can definitely file a complaint, because we always say that what matters is the impact, not the intent. But in this case, IC can have a dilemma that this behavior was fine earlier, but it is impacting now. To that, I think even consensual relationships are actionable. There should be a line between appropriate and inappropriate romantic relationship at workplace. Some companies have dating policies too. I think it is also possible that this complaint can turn out to be a malicious complaint. But IC should be looking at this with a neutral mindset. In fact, it can be tricky during the investigation because both the parties will confuse the IC. So IC should focus on facts versus feelings in such situations. IC should not start the investigation with a preconceived notion of malicious complaint, because I think preconceived notions and unconscious biases are locks on the door to wisdom. So this is my 2 cents. I think I would love to hear other panelists on this.
Abhinav, she wants to hear from the lawyer.
Yeah.
Sure, Anjusha, pleasure. So see, I mean, I'll go by strict sense that the past relationship has nothing to do what has transpired now. Everyone is responsible for an act. If an act which was acceptable yesterday is not acceptable today, it is a sexual harassment. As simple as that. The law is very clear. There is no gray area in this. It's a sexual colored remark, whether it's a undertone, whether it's a verbal thing, whether it's an unverbal thing, whether it's gesture, whether it's winking of an eye, anything whatsoever. So the past relationship has got nothing to do with the complaint what she wants to make. Separately, if a conduct, like I mentioned, which was acceptable yesterday is not acceptable today, then this is going to be this is going to tantamount to sexual harassment. Thirdly, now when the complainant, so now the IC should not come with a bias here that, oh, they were dating, so she would have also done something. They should come without any prejudice. They should be very, very stern. They should be very, very unbiased towards their approach, should examine the case on the merit, examine the complaint on their merit, seeing what transpired, what happened, what went wrong, where. So it's a matter of within second, a good relationship can become bad and then ugly in minutes. So it just takes that much amount of time. So IC, the most important player here in the entire scenario would be IC, because we are all humans and they are also humans, right? They would conceived notion about it. Oh, they were dating. I saw them at that restaurant. She was also probing. She was also provoking. She was also irking those comments. At that time, he did not complain just because she's a girl. This would happen and all that blah, 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 blah. Nothing doing. Examine the complaint as it is. See whether there is sexual harassment ingredient present in that complaint. Examine it and take proper due course redressal mechanism of what needs to be done in the way IC would do it.
I just wanted to add that, apart from, what Anjusha said that about malicious intent, is that that is based on the evidence that is given. So it shouldn't be a, preconceived notion that the IC should come up with. And also to secure the interest of the employer in their company policy, they can add, something on dating and fraternizing, so that when employees get into a personal relationship, it doesn't stem into, or, it doesn't result in, these kind of allegations and cases. Because at the end of the day, it is also a risk for the employer when it comes out, in the public domain after, conclusion of the proceedings or whatever, so that, public in general would, not be sure if the company or the employer is, is zero tolerant towards sexual harassment, or, if it's otherwise. So, yeah.
See, different organization to each his own. Just to add to Sam's view here, different organization, different view.
Yeah.
I've known organization where dating is not acceptable at workplace. I have seen organization where they promote this kind of work culture, so that because the nature of the work is so entails so much of time and effort at workplace, so they promote that, and probably they give gift coupons, vouchers, people who get married in the same organization. So different organization, different culture. There is no straitjacket formula here that this is done, this is not done. You should allow dating, you should not allow dating. They're two consenting adults. when things go bad, they come with vengeance. And this is the problem that rarer action is in virtue than in vengeance. So we should not come with vengeance. Um, we should just restrict to what has happened and whether it has hurt the emotions or whether it falls under sexual harassment. As simple as that. Um, Good dating or not dating policy, like someone has also asked there, would not be clear cut answer to everything. So depending on organization values, ethics, core management views, appropriate steps can be taken.
So there's a very interesting question saying that please elaborate on dating policy. Would you all want to speak about it? Is there any thought that what is the dating policy all about? I'll start with a little bit what I understand from the dating policy perspective, that as Abhinav rightly said, the organization has to figure out what is it that they want to do. If I work with an organization which says that consenting adults can do anything outside of the office premises, I don't care. Okay, they're dating, not dating, it's not my problem. So there are these kind of organizations. There are kind of organizations who say strictly no dating. You cannot be in relationship with a team member within your organization, and if you're there, then one of the persons has to leave the organization. Third kind of organization, as Abhinav rightly mentioned about, and that I know, they encourage people that if you have a relationship, great, but there is a policy to it saying that if there is a relationship, then you'll have to declare it within the organization, saying that I am dating X person, and they have to put it, they have to give an application in HR. HR will look at it that they don't have any kind of reporting relationship or any relationship where they're influencing each other's candidature. And if they are doing that, they will be put in different departments, only that. Okay, that is taken care of. And if there is any sexual harassment complaint that comes up, then they look at it that, till what time was this relationship consensual? When did it become? And very beautifully narrated by Anjusha and Sam also, where they mentioned that, till when the relationship was okay and when did it turn sour, and all that is looked at. I hope that is good enough. And any of you all want to add anything to dating policy, can please help here.
You rightly mentioned, just to summarize it, as you rightly mentioned, there should not be any conflict at the end of the day. If there are reporting, that is also because of the fact that you don't want anyone to have detrimental interest, or their interest could be in detriment, or there could be a favor which could come into play. So there should not be any reporting structure aligned. If that is so, they would say that, okay, you probably from XYZ department, you could move to ABC very politely, and from that perspective, that is doable. But yes, mostly in India, and also like someone rightly mentioned, one of the participant, that yes, most companies have a very strict no policy, because they do not want to get into the contours of this entire process, whether it's good, bad, what. So they would just go with strict disciplinary process, that no dating, that means no dating. If you do, that's a disciplinary action. So they do not want to get and reinvent the entire wheel, whether who did what and who said what happened and what did not happen.
Yeah, and sometimes if the organization do not want to interfere too much, they just put a clause mentioning that if it is a reporting relationship and if you're dating, then kindly report, So that can solve a majority of the conflict which can arise out of the professional relationship.
Oh, beautifully said. We'll answer your questions after we finish, because we have loads of case studies. I can see a lot of pings coming in for questions, so we'll hold that up. I move to another question and I come back to you, Abhinav, for this. So this is a relationship between two key executives. So they are C-level executives. Now the male in the relationship, or the male in this case study, is the CEO. Got sour, and the woman in the case study filed a complaint with internal committee alleging that the man spreads rumors about her alleged physical relationships with a client of the company. Okay, now can IC take this case? Now I don't think there is a mutual relationship between romantic relationship between the two, just that they are two senior people. Okay, yeah. And gentleman is spreading rumor about it, about her relationship with.
Probably,
Yeah.
thank you, Smita. Probably an additional twist could be to this entire scenario, to this case study, is that they were in a relationship. They probably got engaged. That is the actual facts. Okay, they got engaged, and then it became sour. So how do you deal with such situations when both the executives are at senior position and one is the CEO of the company? So can IC take the case? I mean, I would have love to hear the participants, but unfortunately they're on mute to have kind of an engaging discussion. But so I'll just come strictly to what the law is. So at the outset, we should understand the term employer is defined under the Act. And now who's the employer? Who's the head of the department? Who's the head of the organization? Who's the head of that particular place? There are several judicial precedents which have interpreted as to who the employer would be, and it means that a person who has the ultimate control, supervision, and management of the affairs of the company. Now, in this scenario, the male being the CEO of the company would definitely qualify as an employer under the POSH Act. Now, there is another stipulation under the POSH Act that if there is a complaint which is to be made against the employer, it is to be made to the local committee which is formed at the district level. So now in this scenario, what happened was that when the complaint was filed to the local committee, because of the fact that it is pandemic time and unprecedented times we are all functioning in, the LC could not take cognizance of the complaint. They were not in function. They were not functioning. Now this becomes a big issue for the concerned women employee. She comes back, she requests the IC, you take my complaint. IC at the outset was a little reluctant because of the fact that they do not have the adequate powers to inquire into this kind of a complaint because it is against the employer. The act or the law is very clear that if the complaint is against the employer, you should need to report it to the LC. Then she again requested. So at the end, the IC deliberated and also came to that conclusion that if they deny, justice delayed is justice denied, because you never know when these people or when these employees, no problem. When these employees, when LC would start or would become operational. So she requested. So what we suggested was that you take an undertaking from the concerned complainant saying that you are requesting or you have requested, and it is at your instance that we are going to inquire into that complaint. And tomorrow you would not challenge that IC had no powers, and this was done at their own suo motu as discretion, and you would not challenge this because we're just doing it because you have requested, and we want to ensure that there is no case of sexual harassment, or whether there is a sexual harassment case, the respondent should be punished. Now, when the IC was formed, then she again went a step ahead and she said that it is conflicted because all the members of these IC are reporting directly to the employer. Now, what do you do in such scenario? Then, because, and she's right, because the law is also very, very clear that judicial precedents have held that there should not be a mere possibility of a bias, but a real apprehension of it. And in this case, this was a tricky one because there is an apprehension, because right from your reporting structure to your performance parameters to your KRAs to your variable bonus, everything is done through the CEO. So there is a direct conflict, there is a bias there. So what we would advise that you add more additional members, external members, you add more external members in such ratio that the composition of the IC is always odd. A. B, what you do is that since she was the senior member, the complainant was also the senior member at the IC, and she was the complainant here, so she cannot be the presiding officer. So what we suggested, you ask someone senior from your sister concern or from an affiliate company to preside over this, who has no conflict of interest. So this is how we resolved the entire scenario when it was a complaint against an employer. So that if tomorrow she also challenged, we have enough paper trail to demonstrate that what we had done was in accordance with the law, as at her discretion, at her request, because we could have sat back and we could have just said that no, we do not have any, we are not responsible for this. The onus is not on us. You may and go file at the LC level. But what we did is a step back because our organization has a zero tolerance policy towards it, whether it's the CEO or whether it's the workman at the lowest level. Equal treatment to all when it comes to sexual harassment aspects.
Yeah, thank you, Abhinav, for this. And I remember this conversation sometime back. And what was very painful was that we were trying to look for IC to support, LC to support her. And unfortunately, LC of one particular region were not aware LCs of the other, maybe neighboring region, right? So that is also quite a, we are so constrained to help any employee as an organization when we really want to do it. While we understand it's very easy for us to tell that go file a case with LC, but then where will that person go and hunt? So I think we also, I am actually constantly working towards this, is getting the addresses of all the LC members across India, pan-India, every district, so we can have some kind of a directory. And I'm constantly working on it. It's a huge project. So I would urge everybody, whoever has any LC member data, we should be starting to collate it. It's not easy to find who are the LC members. Thank you, Abhinav. That's a great case study that you took us through, and very important, because there have been instances where we are struggling when a CEO gets named as an accused. That where do we go? We do not know, where is LC existing, and we cannot be keeping quiet about it, right? So in one of the instances, I wanted to share that what we had done is the parent company of that organization took up that case, said that, okay, we will help, but they are sitting outside of India. So there was another issue, that was it okay to do it that way? We said it is better do something rather than just not doing anything about it.
Absolutely. And also, sorry, just one more point here. I know we are positive of time here, but it's also a reputational risk when a CEO or a CFO of an organization gets slammed of a sexual harassment case. That means there is something which is definitely is wrong and has reputational value to it. And then it becomes more tricky. And I'll connect with you offline. So we have something for at the LC level, which I'll share with you. Something, whatever I have, we will be happy to share with all the members also. That's not an issue.
Absolutely. Thank you so much for that. Now, I come to Sam. Sam, this is for you. That there are two women involved. A and B are women employees of PQR company having 25 employees. A from time to time circulates sexual material to B on WhatsApp and makes sexual jokes about B in her presence. B files a complaint under the sexual harassment of women at workplace. Now, a woman against woman, is it possible? Is it maintainable?
Yeah, so this judgment that came up, it's based on a recent judgment of Calcutta High Court. It is Dr. Malvika Bhattacharjee versus Internal Committee. So the consideration that came before the court was that whether when the respondent is also a woman, and then who has verified the complainant in public, and can the complaint be filed under the POSH Act? So that was the main consideration. And the court went into depth to look at the definition of sexual harassment. Now, sexual harassment doesn't, doesn't restrict itself to any gender. The definition of sexual harassment, A. Second is that if we look at the definition of respondent, even there also the word person is used. So again, it's gender neutral. So the court said that in these changing times, it's important to look at the backdrop and, the social perspective, and, to understand that even a sexual harassment complaint can be filed against a woman employee, another woman employee, where any such act of, sexual harassment has taken place. And the main consideration is that the complainant because it's a legislation that is so, the intent of which is to secure the interest of the complainant who's an aggrieved woman under the act and who has suffered, sexual harassment. The intent is to ensure that the whoever is the respondent, or the complainant, the complainant gets enough measures under the act. So that's why the court looked into the definition of the sexual harassment respondent, and then it said that it extends to even women employees where the respondent is a women employee, and it does not limit to any gender, the act itself.
Samrita, what gets tricky here is to prove that this was a sexual harassment. Okay.
True.
I think that's because it's a woman to woman. So to prove that a sexual harassment has happened and should IC be involved gets very tricky, because how do you, it could be a friendly banter. It didn't have any sexual connotation. It's like two friends exchanging jokes. So this is something which could get tricky and could become a borderline.
Yeah, so I understand where you're coming from, Smita, when you say that because it's a woman, the respondent would be a woman. And in the case of a man, had the respondent been a man, the automatic presumption would be that, the woman or the complainant would get offended naturally. But, I agree with you partially, but I think that, even if two colleagues of opposite genders were friends, there is something the act focuses on the point that, any such unwelcome behavior by any colleague, because at the end of the day, it's a workplace. No matter how friendly you get or whatever, banter you have, it is ultimately as to maintaining the decorum. And it is on the complainant to feel that if she feels that, this is not welcome, then that should be the consideration based on evidence, of course. Again, if it's, something that is done with malicious intent or something, then again, you have, relevant provisions under the act to safeguard the respondent in that case. So I think that shouldn't be taken into consideration, although I think it's a society thing partially when we think that, the opposite gender is a man, and, people naturally jump at conclusions that, it could not, in case of a woman, it cannot be, sexual harassment case typically. Yeah.
Absolutely. Thank you for that, Sam. I come back to this, Abhinav. This is for you, and this is one of our last case, actually our last case, because we wanted this to be open to the audiences to ask questions and we could respond to it. So this actually came like today in the morning to me, and I think the person who asked has also joined this discussion. So this is a case where a woman is working in a night shift for an organization. So she goes for a break and comes back at around 11:30 p.m. Now she must pass through a cubicle to get to her desk, right? She notices a group of men who are chatting around, but she ignores them and moves on. When she walks few steps ahead, she hears a male voice saying, "Humse milke jati." It's a Hindi word for saying you could have met us too, right? So it's a slang for saying, okay, at night you have gone to meet somebody and you could have, why you didn't meet us also. So she gets extremely upset with that and continues without even turning back. Now she has reported this case to HR. Unfortunately, she does not remember or recognize these men because she had not paid attention, and she did not turn back on listening to that comment also to check who those people were. It's a large organization. There are a lot of people working in night shift. So she's not sure who it is. Now, HR has approached you, I see, to understand if this is SH case. What will be you advising them?
Thanks, Smita. I'll keep it very, very brief because I'm conscious about the time and I want everyone to ask at least a couple of questions and make it a little more engaging. So I'll keep it very, very brief here. In my view, humse bhi milke jati, in whatever connotation, in whatever aspect, it is something which has a sexual colored remark to it. It will fall under the definition of POSH. Because POSH also has a definition which has a residuary category, and it would entail anything which offends a woman. you talk about anything which can offend a woman would be sexually would be considered under the definition of that, with just a bit adding a sexual tone or having a sexual context to it. That's about it. So yes, Humse Bhi Milke Jati is a sexually colored remark. So definitely would fall under the purview of the definition. Now, what next? At the same time, we are all aware that the POSH Act, and I'm not going to delve into the section, I'm just going to make it very, very general, that the POSH Act specifically provides that a complaint needs to be in a particular format. There has to be 6 copies submitted. It has to be in writing, the date, the time, the event, the place where the event happened. It all has to be there. Now what? If this is a case of sexual harassment, she could have filed directly to the IC, but the IC would definitely reject it, basis saying that we cannot have an anonymous complainant, and we cannot also have a complaint where the respondent is not mentioned. So that is also not correct. So what in this scenario should ideally be done is that what you need to do is that the HR role will become very big. Now HR needs to assess, because this has gone to HR. Now HR needs to assess. And how will HR assess? The first thing first is that HR needs to know what time this thing happened, what was where, which cubicle she passed through, take references of CCTV cameras here. And after that, if you think that there are 4, 5 people, 6, 7 people all all were sitting there, and anyone could have possibly said such a statement, what do you do? Because confidentiality is also a very big aspect, like fellow panelists discussed in the preceding slides. Confidentiality is also very, very imperative. Now, what do you do for that then? Then the HR should enter into an NDA with all those 7, 8 people. That because we don't want a situation tomorrow that you, after interviewing those 7, 8 people, 10 people, after figuring out what time it was there, you do not want a situation wherein that it spreads like a grapevine in the organization. You would not want that. So you enter into a kind of an NDA first, interview them, and interview with an open, have an open dialogue kind of an interview. Do not force that, or do not allege that it is being done. Be very clear, be concise, and be very clear, record everything, assess that information, and then come to a logical conclusion if you are able to find who the respondent is. Then that complaint can be made by the complainant directly to the IC. He will examine that complaint based on the merit, whether it has sexual content to it, whether Humse Bhi Milke Jati is sexual in nature. Then IC would say who the respondent is. Respondent could allege, I am not that. It's all a matter of inquiry then. Then it is all a matter of evidence then. It is all a matter of witness there. It is all a matter of recordings then, that you were sitting at this position, the CCTV cameras were in that particular direction, what you said, what you did, it corroborates with the entire events. So that circumstantial evidence would also come into play, and all that has to be done. So to answer it in brief, HR role will become big. NDA should be signed because you want to protect or ring fence the company's interest. That is more important.
Brilliant. Thank you for that. So I will be advising, and I hope the person who asked me that question is there and listening to you, Abhinav, because
Sure.
Immediately when I heard that, I said, I'm going to ask this to panel members, and here the question is, and thank you very much. So it doesn't come to IC yet till we identify the respondent, is something that we would want to leave them with. All of you, thank you very much for joining in. I think it was a very interactive conversation that we had. I have put on our social media tags where you can go like, comment, because we keep on sharing a lot of things there. I would want to stop share and start asking questions. Before that, any closing comments from each one of you, Abhinav, Sam, Anjusha?
I said I've spoken enough. I mean, I would like the participants to speak now, because they would be my voice would be raging in their ears. So I would want them to speak anything. Otherwise, I'm happy to conclude. That's not an issue. But I'd be happy that if we can take a couple of questions.
Sure. I think there were a couple. Oh, they're all thanking you, Abhinav, and all the other people. 1 minute. Okay, what is NDA?
Non-disclosure agreement.
Non-disclosure agreement.
Confidentiality agreement. That whatever the interview would be, this information will not be shared with anyone, with any of the employees, customer, clients, relatives, anyone. It's just between one-on-one.
Thank you. Thank you, Shivani. There's one question. If there's a company having chain of shops in various states, a few of which have less than 10 employees, would POSH Act be applicable to these shops individually or to the company as a whole, since shop could be registered under shop and establishment, thus entailing it to consider. Also, it is applicable to shops.
I mean, I can understand the question. That's a very fair question to ask. See, the applicability of the act is restricted to 10 or more employees. So the establishment which do not have 10 employees would not be required to form an IC. Basically, the requirement is of IC which gets triggered at 10 or more employees. The POSH Act will be applicable at each organization, but the constitution of IC is contingent on 10 or more employees, right? So IC is not required. POSH Act as in at all establishment could be there, so you would not have to form an IC at that particular establishment. You could have a common policy, you could have a common IC who could take care of those employees at that level, or if you can also have local participation, that would be good.
Yeah, to add to what Abhinav said, I'd like to say that it's at the discretion of the employer in that scenario. So then in that case, even if women suffer any, or they have any grievances with respect to sexual harassment, in that case, there is no redressal under POSH Act because it's not a mandate then. It's at the discretion of the employer.
All right. Thank you so much, Sam, for that. I have another question from Renuka, who says that how do you collect evidence when she does not know the men and there are no CCTV?
And there's no CCTV, there's no around.
There's no evidence.
Yes. Then you would, and you can't create evidence. So then you would have to assess what time she passed by, which corner she went through, how many people were sitting on the left. Your work will be a little more tedious, but I doubt there's going to be some register. There's going to be some swiping that somebody entered at this time, she entered at this time. There would be some access cards. So you would have to check out the details. Like, for example, she punched in at 11:29 and entered through the glass door. Who all were present at 11:29 at that particular time. So you would have to think out of the box here. There's no straight bracket formula to determine how would you come to the conclusion. But where there is a will, there is a way, and I'm sure there would be this kind of things could be assessed to come to a logical conclusion.
Awesome. I think, yes, it becomes very laborious if you don't have CCTV.
Yeah, and to that, I was just adding Abhinav's idea that, as HR, we know how to find data,
Yeah.
We know where it will be, or the, access card, the system that we have in place.
Exactly.
I think it may be tedious, but yeah, it is not impossible.
So one could also be a situation when she logged in, what time he logged in, what time the system logs could also help you. Then there are registers, records, and there are a lot of restriction also. When a women employee is moving at 11:30 and working in a night shift, that means that it has to be an IT/ITS system. Let me be very candid about it. So if it's an IT/ITS establishment, there are a lot of other regulations and guidelines also which are prescribed to ensure protection of women employees. So there would be some register, some record, some would have accompanied her when she would have walked down that door. Something of that sort would be in place.
Absolutely. I think Sundarajan's question you responded to, right? A team member.
Yeah, that because that's not a case. There's no sexual harassment aspect to it, Smita. That could I mean, what I could gather from that complaint or from that query is that there is no connotation of sexual harassment there.
Yes, I'm just trying to go through that. We have covered all the questions.
Sure.
Yeah, I think we have. If we have not.
I would like to ask something, if you please allow me.
Yes.
Neha from Jaipur. Good evening.
Go ahead, Neha.
Right. First of all, good evening, everyone. I'm Neha from Jaipur, and I'm working as a POSH consultant. And I'm also partnered with the KELP HR for Rajasthan region. So already working with Smita. Now, I had a query about it that I have been to the districts like Jodhpur and I'm already into Jaipur. Now, when I spoke to Jaipur dignitaries, the people in the authorities, they said that we have responsibility to handle cases only of government regions, government departments. Now, they are not taking responsibility of the private companies if something comes to them as an LC kind of thing, right? The LC is over there. So do we have any national body from whom we can make them communicated that you are responsible for the private sector as well? Because you know the awareness level in the north side and precisely in the west, like Rajasthan. So they are not ready to take the responsibility, of course, because of the lack of awareness. So do we have anything that can come from higher ups, because that's the only way they understand? So do we have any national body for this, or a particular email ID where we can drop and we can discuss them and collaborate with them? If they can implement this into these smaller strict districts where they can have a knowledge base also.
She's looking for a chadi.
Yeah, because these people, they have just very upfrontly said that we take care only of the POSH cases that happens in government organization. So what about the companies, the industrial area? They are small units, the MSME sector, which are privately owned. So how can we work on this? That was my question. If we can have something to refer to.
I don't know. I mean, just off the
Actually, it's a very tricky question. There is no straight answer. I've been working in this space for last 8 years. I wish I had a response to your question. We don't have a response to your question, unfortunately. We're trying our best. Having said that, I have been constantly trying my best to see how I can reach out, help, collaborate. I think, it's just a multiplying effect. I think we also have to take charge, right? And that's what I have started doing. As an external member, as a responsible citizen, what can I do in my circle? Okay, can I do something and then create a multiplying effect? All right, government is having multiple issues and this is one another issue, right? So let's take charge.
Because the sexual harassment cases are the one where government is least active and they do it as their accessorized part, or the people who are placed here. I'm talking about Rajasthan. I don't know about other places. But people here in Rajasthan who are working in women and child department are considered as the punishment postings. So the people who are not interested in working, they are given this women and child department. So in that case, I mean, that becomes really difficult to make them convince how important their role is. So they are playing equally so important role. And these government people are really so reluctant. They just straightway say, ये हमारी जिम्मेदारी नहीं है, हम यहाँ का नहीं देखते. They just need the reason to say no, but they don't understand it actually comes into their purview. So that's what I was finding. If we have some email address or some contact person who we can.
So let's find it. Neha, let's take it as on us to find it and come to the response. Yes, she is from the state of Rajasthan, Bhavri Devi K. Sruta. And I think Roma was asking us to have more similar sessions. We do these sessions every second Saturdays of the month, every second Saturdays of the month, we pick up a topic on POSH and we do a lot of sessions. So please join us, all of you. It will be happy to hear all of you. Okay. And one last statement from each of the panel members and we wind up. I know we shut up by 9 minutes and Anjusha has left something important to be. Yes, Anjusha, we ask you to start first.
Yeah, so but I mean, I'm really enjoying the session. Unfortunately, we have to branch off now. So when, as I see, we are working on tricky situations, it is very difficult, to run the entire investigation and end with a appropriate result. And it is easy to get carried away by our own unconscious biases. But, the only thing is, let's make a conscious effort to be neutral as much as possible while handling these cases. Be curious, not judgmental.
That's brilliant, Anjusha. Chalo, let's see if Abhinav can match that.
No, I'm afraid I cannot. That's a good punchline actually. So I'm afraid I'll I mean, we could start from Sam and then I could just conclude. Ladies first. I mean, if she's
All
better.
right, all right, the other way around. Sam?
Yeah, I mean, this session has been really enriching in terms of exchange of knowledge. And also to add to what, like I'm sorry to go back to the question where we were discussing about respondent not being identified. There is also a requirement under law that, the complainant need not have to prove it beyond reasonable doubt. So it's one of the principles that we have in natural justice. So that is also something that is important. And if 50% of the IC are convinced that, there is a case of sexual harassment, then, then the complainant would not face so many issues in terms of, identifying the respondent. And yeah, coming back to the conclusion, yeah, I'm sorry to deviate. But yeah, I mean, this session has been really enriching and I'm glad we could all connect, even the audience, the viewers who are there, they've been so cooperative with us, listening to us. So yeah.
Thank you, Sam.
Thank you so much.
Abhinav, we come to you and then we go back to Sundar Rajan. He has an answer to Neha's question, I guess.
Sure. So I'll just take a minute here. I'd like to thank everyone here. I'd also like to thank my colleague, Diksha, who was here, who had helped me prepare this presentation and go through it. So thank you to Diksha if you're here. You, Smita, and to all the members of KelpHR and ILA. Thank you so much. That's about it. And would have loved to have more engaging session here, but unfortunately time and
You're definitely in demand, Abhinav. I see a lot of questions which were marked to you. So definitely.
I'll say God is kind. So
So I thank you very much, panel members. I really enjoyed this conversation and it's my favorite subject. And if I get like-minded people, I can go on and on and on. That's why the step over of 10 minutes that we had. Anjusha, we let you go. I think you should. But I'm just asking Sundar Rajan to respond to Neha's question, and he said that he has an answer. So would love to hear him. Sundar Rajan, are you there? No worries, Sundar Rajan. Do one thing. You can write to me at smita@kelphr.com.
I should do that.
Yeah, you can write to me and I will circulate it in this group, whoever has it. Yes.
Because there is a Mumbai High Court decision wherein it has said when a lady raised a dispute with the High Court, and the High Court said that such appeal should go to the tribunal, which is said in the law.
yes.
But the Mumbai High Court did not have a tribunal. High Court passed an order for the government to form the tribunal and hear the case. And High Court will not listen all the violations of the process done by anybody. So then I saw that about 2 months back, the Mumbai government formed a tribunal to hear the case and go forward. This is the answer for Neha.
All right, Sundar. Thank you. That's about appeal. Thank you so much. But Mumbai has started it. I guess it will be the multiplying effect I was talking about across the country. So that could happen. Thank you very much for lovely panel members and lovely audiences for asking us so many questions and triggering our thought processes. Thank you very much. I sign off. Have a lovely evening ahead.
Thank you, everyone. Thank you.
Thank you, everyone.